that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Khumalo is also complicit in the murder of Senzo Meyiwa?
My Lord, yes, I presented all the evidence as it is, and as I indicated, part of my recommendation or request was that she should be charged, but then there were further instructions insofar as she is concerned at that stage, my Lord.
What has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP, and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial fact which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that.
Is it please the court, my lord? Now, you constantly has been mentioning throughout your testimony that Kelly Khumalo is the mastermind behind the death of the deceased, Senzo Meyiwa, not so?
Yes, my Lord, based on the investigation, not my assumption. I mean, I think I made references to where her name comes from, you know, and that starts from accused one going up to, you know, and then obviously then the investigation that we conducted. So, but it starts from there, my Lord, going up.
Thank you. Is this a narrative that is also shared, or that was also shared by the prosecutors who assisted you in this investigation?
I don't see the relevance of this question. There was a decision to prosecute the current accused before this court. As to what view the prosecuting team held is irrelevant. So we have to focus on the accused that are before this court.
The court, my colleague should not be understanding me as not being concentrating on this case. The witness, my lord, has testified many a times that there were certain things that it did not do because it did not have specific instructions from the team of prosecutors who were assisting him in investigating this case. Consistently maintained that Kelly Khumalo is the kingpin in the assassination of the deceased in this case. I don't know, therefore, on what basis it is then alleged that the question that I'm asking him as to whether or not the team of prosecutors who assisted him shared the same view that Kelly Khumalo was a kingpin in this case. I don't know on what would then be the irrelevance of that question, my lord. Thank you, my lord. Did the team of prosecutors who assisted you in this case also share the same view? Were they part of that narrative that Kelly Khumalo is the kingpin?
So my lord, I wouldn't say there was a narrative from the prosecutors. Evidence that was collected, my lord, at some stages I indicated was presented to the DPP, and further instructions insofar as Ms. Kelly Khumalo were given, up to the point where we read the statement that I made in November, my lord, and I indicated that there was no decision taken at that stage, you know, to bless the arrest of Ms. Kelly Khumalo. So there wasn't an objection. It was a question of further instructions and the adoption that the NPA was taking at the time, my lord. That's my answer, my lord.
I did not get really what my answer to my question is, because the question is very clear. Was the team of prosecutors, or was it part of their narrative, their viewpoint, that Kelly was the kingpin in the assassination of the deceased in this case, irrespective of whether Kelly Khumalo was charged or not, did they hold that view in terms of your discussion? Remember, your discussion is not privileged. It's just not privileged, which is the reason why you had to come and tell this court that they gave me these instructions, they did not give me those instructions, I did this because of what they told me, they guided me here and there and there and there and there and there. Do you understand? Now,
I understand.
the question is, were they part, was it their narrative as well that Kelly was a kingpin? Thank you.
The witness has answered that question. Must he repeat his answer? If so, what is the reason why he should repeat the answer that he's already given, my lord?
Maybe I did not get your answer, Brigadier, and there is nothing wrong in me requesting you to repeat your answer. There's definitely nothing wrong in requesting a witness to kindly repeat your answer.
The essence of my response was that there was no decision taken. Insofar as the sharing of the narrative, my understanding, and this is how I've been dealing with the NPA from time memorial, you conduct investigation as a police officer, you present the evidence to them. They decide as to whether to enroll the matter or not. And then if there is a need for further investigation, such will be communicated. And I've testified about this, my lord. So I'm not so sure if I can take it further than this insofar as what the advocates, because I can't get into their minds. What I know is what I presented to them and the responses that I've got, my lord.
Thank you, Brigadier. Let us embark upon a standard 3 approach. Was it part of the prosecutors who were assisting you? Was it part of their narrative that accused number 1 is involved in the commission of this case?
I beg your pardon? The relevance of the standard 3 approach. We submit, my lord, that the court has referred to the case of
Yeah, I thought that case I gave you guys.
Azaf, and we
Here's a
thought-
brigadier.
Yes,
He's being referred to as a standard 3.
yes, and
You must approach him like a standard 3.
No, with due respect,
Okay,
that
I'm
is
not
what
going
I'm
to
saying.
argue that point. That's how I view it.
Yes, but my lord,
Let's resort to a standard 3 approach.
no, I am saying, let me take it step by step so that we understand each other. But I'm not saying that the brigadier is a standard 3, my lord. I would not have intended to say that. I am saying, let us simplify my question in the following sense. Brigadier, let me put it this way. Let me simplify my question. Let's not make meat out of the fact that, let us not make a mountain out of the ant small, that I said, let us have a standard 3 approach. But what I intended to convey to you is that let us take it step by step. Maybe language is it's failing me. Thank you, Brigadier. But if you feel a little bit disrespected, my apology in that regard. Thank you, Brigadier.
Understood, my lord.
Thank you. Let us take it step by step. Now, was it part of the narrative of the team of prosecutors who assisted you that accused number 1 is complicit in this case?
my lord, accused number 1 has been charged. What is the relevance of that question?
I understand accused number 1 was charged, but was it part of their narrative that accused number 1 is complicit in this case? Yes or no?
My lord, perhaps to assist, I'll answer it this way.
Yes.
All the accused, 1 up to 5, when the memorandum was taken to the DPP, there was a decision to indict all of them on the charges, on the 5 charges that are before court, as per the indictment. That decision was taken. Insofar as Ms. Khumalo, further instructions were given for me to do. And that is why the statement I read here in court, where I was directed by Mr. Ramsipili, stated the date of November 2014, it was part of those further instructions to say, follow these instructions and then bring it back. And then subsequent to that, then the warrant was not signed. But there was never an objection to say we should not pursue this. I don't know if it will assist, but I will not be able to quote word for word as we're sitting there what the advocates were saying. But there was a desire to say, let us get more evidence to connect. Hence I said, my lord, before this accused appeared in October, we had some evidence against Ms. Kelly Khumalo, which I've explained in this court. Later in November, we had more. We even dealt with the cell phone numbers. That was part of the prosecutorial driven investigation. So there was a working together between myself and the prosecution. But insofar as the ultimate decision to prosecute, my lord, that lies in the hands of the NPA. And I think it will be dangerous for me to venture into that area as to what informed them. But there was a working together in terms of what should be done with regard to the evidence or the pointers that implicate Ms. Kelly Khumalo.
Thank you. I'm still struggling to get my answer on whether or not the fact that Kelly Khumalo is a kingpin in the matter of Senzo Meyiwa was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer. And I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assisted the court. But nonetheless, I realize that there's an objection from my colleague.
As a court, please, my lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and this is the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
And unfortunately, I am not prepared to live with that answer. But I do realize that it's a very difficult one. But nonetheless, let me proceed. You know, the reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they have indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
My lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my lord, was done, and the matter, it's a question of separation of powers, and I've explained this, my lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Khumalo. It's a normal, that's how it's done, my lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my lord, how do I then speak on behalf of them? I think the NPA in this situation, my lord, are better vested with the knowledge of giving Mr. Advocate Mnisi the answers that he seek, because I can't speak on their behalf, my lord. Same with the section or the law that Advocate Mnisi referred me to. I'm not sure, my lord, how best can I assist him there. I mean, that lies between him and I think the court And with greatest respect, the advocate Baloyi, because what do I say, my lord? That's not my terrain as well.
Futhi ke nangumthetho
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
manje ke emva kokuthi ke uwe
My lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrant of arrest. I mean, as I've said before, my lord, J50s are a way of bringing the accused persons before court because the decision was already taken that, they're indicted for these charges. I then took that route, my lord, of applying for J50s as per the affidavit that I disposed, and then that was solely granted, my lord, and then the accused were brought before court.
hayi lokho
Thank you, Brigadier. Further, that part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
futhi ke kuyisa phambili
I suppose, my lord, I'm just not sure word for word now because I'll have to go through to the indictment, my lord. But I suppose if Advocate Mnisi saw it recently, I will not dispute that.
angeke ngiphikiseke lokho uma ukuthi u-advocate mbheke
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Khumalo is also complicit in the murder of Senzo Meyiwa?
manje ke uma usuzofaka lezi ncwadi zakho
My lord, yes, I presented all the evidence as it is. And as I indicated, part of my recommendation or request was that she should be charged. But then there were further instructions insofar as she is concerned at that stage, my lord.
yebo ngafaka konke
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased.
ngithi wena ke wawuwenelisa
Now, this is what the state told this court in terms of section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial fact which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
As it is the court, my lord, I think that is, it's a misdirection, it's a misrepresentation of fact. It can't be had to be said that an information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case, then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid, I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case, my lord. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to,
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed.